everybody. Welcome to the third episode in our podcast series exploring international privacy and data protection laws. Today's episode is part one of a two-part focus on the United Arab Emirates, where we're unpacking an evolving and often complex data protection landscape. The UAE, or the United Arab Emirates, operates under a federal personal data protection framework alongside distinct free zone regimes, including what we call Dubai International Financial Centre, or the DIFC, and the Abu Dhabi Global Market, or the ADGM. For many organizations, navigating these overlapping regimes presents real compliance challenges. In this episode, Katie and I will focus primarily on the UAE Federal Data Protection Law. So that's the general data protection law for the entire country, and not the free zone regimes. This will set the foundation for part two, where we'll look at the more like the free zone areas. So we'll be able to understand how the system works. In our next episode, then we'll build on that discussion by taking a deeper look at the Dubai free zones, like we said, the Dubai International Financial Centre, and the Abu Dhabi Global Market. Across both episodes, we'll explore how these regimes align with international standards like the GDPR. And most importantly, we'll look at what businesses actually need to prioritize in practice when operating in or targeting the United Arab Emirates. So we have 12 questions like we always do, and we'll take it in turns like we always do as well. And I'm accompanied by my colleague and friend, Katie. So the first question goes to you, Katie. So for our listeners who may not be familiar with the region, can you briefly explain the overall data protection landscape of the United Arab Emirates and why it is considered legally complex?
Yeah, thanks for that introduction and question, Maria. So the UAE has quite a distinctive landscape legally, and that's true as well when it comes to the data protection framework. It's a multi-layered or tiered approach. Unlike many jurisdictions that operate under a single national law, but the UAE is almost comparable to, the EU, and they're both unions. So they combine federal data protection laws with separate laws that govern particular regions in the union. So the federal laws have the PDPL, which is the overarching, quite, I'd say, general one that's issued. It was issued on the 26th of September 2021, and they also have a series of sector-specific federal laws that includes banking and healthcare. They have those, and then it also depends what zone or emirate that you are in, because they also have fully developed legal regimes within key zones. So a couple of those is the Dubai International Financial Sector, DIFC, and the Abu Dhabi Global Market, ADGM. So, as you said, we're going to focus on the federal today and then go into the free zones more in the next episode. So it's a tiered approach, and this is typical of the UAE's broader legal structure. It's not just data protection. They have a civil law system at the federal level and common law system in the financial free zones or the particular emirates, and as a result, it depends. Whatever law applies to an organization is going to depend on where you're established, where the processing occurs, and the category of data you're actually handling. So for an international organization, it is useful in a way that a lot of the requirements can be similar to the GDPR, but you need to understand exactly which applies to your processing operations.
Absolutely, yeah. And so you mentioned there, so the GDPR, we've always said it's industry agnostic, so it cuts across all industries. And as well, it applies to all the member states of the EU. Whereas with the federal PDPL, it's not industry agnostic then, is it? And it doesn't apply to specific areas within the United Arab Emirates. Is that correct?
Yeah, well, I suppose I would put it this way. So they have the PDPL, which is I'd say, a general standard for all industries.
Mm-hmm.
But then they also have sector-specific laws that are at a federal level, like from the central bank, that just goes further. So no matter where you are, you might have this, the PDPL level, and you might not have to go deeper than that, basically.
Mm-hmm.
And then, yeah, if you're in Dubai, the DIFC goes a lot deeper. It goes into a lot more granular detail than the PDPL. So then that will apply in the sense that you have more obligations. And I think that's just because they have a lot more international business in those free zones. So
Okay.
I don't know.
So the DIFC and the ADGM are very similar. We'll see it in part 2 as well, but they're more similar to the GDPR, aren't they, than the federal law?
They are, yeah. They definitely go into a lot more detail in areas that the GDPR would, whereas the PDPL is quite surface level. It hits all the right notes, but it doesn't give exact granular detail on the controls and the considerations.
Yeah.
Compared to the free zone laws.
Yeah. And as well, we have to bear in mind that it's a relatively new piece of legislation as well, because it came into effect in January 2022. Do you know what I mean? So we've only got about 3 years of enforcement. So it'll take time to kind of mature.
Absolutely. So we'll go on to your next question here, Maria. So what exactly is the UAE Federal Personal Data Protection Law? When did it come into force, and what is its overarching aims?
Okay, so like you said, Katie, so the legal landscape in the United Arab Emirates is quite complex. So the Federal Personal Data Protection Law passed in 2021, but it came into effect in January 2022. And it's different to the GDPR in that it relies very much so on executive regulations. And these came in 2023, and there's more still to come in. So what I mean by executive regulations is they're kind of they're a legally binding set of rules issued by the government executive branch. And so they would kind of specifically explain how to apply the law. And that kind of happens in a civil law region as opposed to a common law region. So that's kind of how it differs as well with the GDPR. And as well with the DIFC and the ADGM, like you said, they're common law regions as well, common law regimes. So yeah, it depends on, it was passed in 2022. It needs kind of executive regulations for people to be able to understand what obligations they have under the law. And so again, we're talking about 3 years of enforcement. So there's still more executive regulations that need to come online in order for the full enforcement of the law to take effect. The primary objective of the law is to protect individuals' personal data, to regulate how organizations collect, use and share that data, like the GDPR. And it was also put in place as well to strengthen the trust of the United Arab Emirates digital economy. So we're seeing more and more across various different jurisdictions. In order to attract business now, you kind of have to put data protection laws in place. So again, that was another kind of driving force for getting this in place. Importantly, it's also a form of extraterritorial reach. It has, similar to the GDPR, it has extraterritorial reach, which means that you can get foreign organizations to comply with the law if they are processing the personal data of individuals that are located within the UAE. Okay, so, and it's the first comprehensive UAE national data protection framework as well. So very much like the GDPR, it establishes a baseline for rights, a set of data protection rights for individuals and obligations that organizations need to follow. But again, like we said, it's slightly different in that it is a civil law regime as opposed to a common law regime.
So the people really are going to be relying on the executive decisions to understand how to implement it because of the civil law nature.
Exactly, yeah. And that kind of makes me think about the DPDP Act in India, because we looked at that a few weeks ago, and the law came into effect in 2023, but then the rules came into effect in 2025, and they're binding kind of rules to help people understand how to, apply the law, the DPDP law. So even though India is a common law regime, they have also given kind of a set of rules for people to understand the law better. And you can kind of see that here as well in civil law in the UAE. They're giving guidelines how to interpret the law for organizations. So yeah, it's kind of, a few overlaps between the GDPR and the DPDP that we kind of looked at as well. Okay, so for you, Katie, question 3, for clarity, and just keep it brief as well, because we're going to go into much more detail about this in part 2. But would you be able to explain how the Dubai International Financial Centre and the Abu Dhabi Global Market data protection laws differ from the federal law? And why do these separate regimes exist?
Absolutely. Thanks for that, Maria. So the DIFC and ADGM are a lot more similar structurally, and I suppose in the language used to the GDPR compared to the federal PDPL. The actual documents, legal instruments themselves they're each nearly double in length compared to the PDPL. So they go into a lot more detail that we're familiar with in the GDPR, as we'll see as we talk about, the differences going on. So the PDPL has a lot of controls that we're comfortable with, that we'd like to see in a data protection law, but the purpose is different. So the DIFC and the ADGM had this international scope in mind compared to the federal law. So the federal law was very much thinking in a national context, whereas the free zones were thinking in an international context. Like, they were specifically designed to encourage international business and to meet international standards and expectations when it comes to financial services and digital businesses. So just a couple of points here of specifics before I won't get too into it because we're going to talk about it again, but all of the laws have a lot of the same similar data subjects rights, but the free zone laws go into more explicit lawful bases, detailed guidance when it comes to transfers, and they go into more detail when it comes to penalties and non-compliance.
They're much more modelled on the GDPR, from what I can gather, aren't they?
Yeah, absolutely.
And as well, they're a common law regime, as opposed to the civil law regime that we have in the federal law for the United Arab Emirates.
Yeah, basically they exist because these free zones, their intention is to function as a global business centre. So they need to be more on par with international standards compared to the national law. Like, the federal law, they can make a bit more specific to their culture. Like, in previous episodes, we were noting a few things that we thought spoke to the culture of the country.
Yeah.
So the PDPL has a bit more freedom to do that, whereas the free zone laws need to be a bit more corporate, or a bit more,
And as well, I think they made them common law because, you have the UK, you have Europe, they're all kind of common law regimes. So they kind of makes it easier for transfers and so on, and to do business in these common law regions as well, or jurisdictions for, the DIFC and the ADGM. And we had that as well with the Kingdom of Saudi Arabia, PDPL, where it was, a lot of, we saw within the law, we saw a lot of kind of, specializations towards their culture, considerations towards their culture and what was important for them in their culture. And they kind of modeled their data protection law towards their culture. And so it's, it's similar as well with the UAE. The federal law is more specific to their culture, I think. And like you say, then they kind of allowed for the DIFC and the ADGM to be more internationally focused.
I'd say that's the main distinction.
Yeah.
And reason for me, I'd say. So I'll move on to the next question here for yourself, Maria. So how do organizations know which law is going to apply to them?
Yeah, so again, like we've said, it's quite complex. You have the overarching kind of federal PDPL, you have the DIFC law, and you have the ADGM law. So it depends really on where the organization is legally established. And that's similar to the GDPR in that, you have the main establishments under the GDPR, and then that kind of determines which is what supervisory authority you're be reporting to and so on. So it's similar in that respect. If an organization is established onshore in the UAE, it generally falls under the federal PDPL. If it's established in either of the DIFC or the ADGM free zones, then those laws would apply to the organization. The complexity actually starts to arise when organizations operate across multiple zones. So you have an organization that's in the DIFC, the ADGM, and then onshore as well in the UAE. So you have a case where, you have shared service models or international cloud infrastructures, and that gets complicated then trying to understand what laws apply. If somebody's data is stored onshore, but they're actually located in the DIFC or something like that. But so we'll look at that in more detail next week. But just, for the time being, just bear in mind that it's important to understand where the organization is established, and you have to consider, where the data is being processed as well in order to determine, what law applies. So I suppose it's worth just noting as well, though, that, it's similar in a way to the GDPR in that, it's kind of a layered approach. Like the GDPR sits at Brussels and it's enforced across the member states, but then the member states they have kind of a little bit of freeway to interpret the GDPR and to bring it into their own statutes and so on. With the system in the UAE, you have kind of the general federal law, but you have kind of separate zones. So that's slightly different to the GDPR in that, the federal law does not actually apply to these separate zones, whereas the GDPR applies across all member states. I think that's something.
Yeah. That is a notable difference, actually.
Yeah. Okay, but again, like we said, we've broken this into kind of two parts. So we're kind of focusing on the federal law today, so we'll leave that for the time being and we'll get into more details. And if you're interested in the DIFC and the ADGM, make sure to listen to part 2, because we'll get into much more detail in that episode. But now let's move on. So question for you. Next question, Katie, is question 5. To what extent does federal United Arab Emirates data protection law mirror the GDPR? So again, we can get into more detail here about, what's the similarities and what's the differences.
Yeah, so the PDPL is clearly GDPR inspired. The structure is quite familiar. It uses a lot of the same definitions. It has the same controller processor model. It has a lot of the same data subject rights. You need to have technical and organizational security measures. They have their data breach and notification requirements. They have risk assessments where there's higher risk processing, and they also do regulate international data transfers. So if you're an organization already operating under the GDPR, a lot of the concepts will be familiar. The main difference is detail and emphasis. So as we've seen with a lot of the other laws, their legal processing is consent-based. So they put, I suppose, consent at the forefront of lawful processing. The scope again, is more fragmented because of what we've been saying and what we'll go into more detail in the future. And I'd also say the cross-border transfer mechanisms are given less attention. But of course, there's going to be more executive decisions on the implementation of that. So it's important to know that there are federal laws for specific sectors like banking, finance, and health that you're going to need to, even if you're not in the Dubai free zone or in the other free zones, there are still more laws that might apply to you than just the PDPL. So if you're a financial service operating outside of the free zones, you still have the central bank rules to abide by, and they go into far more detail than the PDPL, and they have significantly more operational burden compared to the bog standard, I'd say, federal law. So you need to pay attention to whether you're in the free zone, what emirate you're in, what sector you're in. It's a lot more layered, I'd say. Another point is enforcement. So there's a lot less guidance on enforcement compared to the GDPR. There's less information on how fines and penalties will be doled out compared to the GDPR and compared to the free zones and compared to the sector-specific laws.
Okay.
So yeah, GDPR is a strong starting point, but it's a layered approach, and you really need to map what laws are going to apply to you, because it can be a huge difference as to whether just the PDPL applies or whether the PDPL and the central bank laws apply. It's quite so
depending on your industry. So it's not, like we said before, it's not industry agnostic like the GDPR. You may have to enforce the federal data protection law, PDPL, as well as other industry specific laws. Okay. Another thing to remember as well is that it's actually the UAE is a civil law regime, whereas the GDPR is a common law regime. And like I saw something that was kind of nice and kind of summed it up for me anyway, was that with the UAE, the question that you need to ask is what law applies. So you have the free zones and you have your industry laws and so on. So it's more about like what laws apply in this specific situation, whereas the EU, the GDPR applies everywhere, and the important thing to understand is like where is your main establishment. So the one-stop shop mechanism helps you understand, what specific national laws apply to you, what regulator you report to, and the courts that will be important to you under the GDPR. So I thought that was interesting as well.
Yeah, that is a good summary of it. So we'll move on to question 6 now. It's about the individual rights. So what rights do individuals have under the federal PDPL, and what can businesses do to facilitate these rights?
Okay, yeah. So the rights are quite similar to the GDPR rights. Individuals are granted quite a solid set of data protection rights. And if you're used to the GDPR, it'll feel quite familiar to you, these set of rights. They include the right to be informed about how the individual's personal data is being processed. They have the right to access that data, to correct the data if it's wrong, and to actually even delete it if they want. They have the right to restrict or object to certain types of processing, again, like the GDPR, and they have the right to request the transfer of their data to, another service or whatever. So the law recognizes protections around automated decision making as well. So the whole idea of decision making or automated decision making is less explicit than the GDPR would be. But they do have the ability to object where processing produces legal or similar, automated processing produces legal or similarly significant effects. So in practice, this means that businesses must put proper operational processes in place, like, again, with the GDPR. So it's not just about putting policies and then forgetting about data protection. Organizations need to have clear privacy policies. They have to have mechanisms to receive and respond to data subject rights. Like the DSARs that we have under the GDPR. they should put in internal controls to locate and amend or delete the data. So they need to understand where personal data is being stored. So again, you would have to do that kind of mapping, procedure like under the GDPR. And even though ROPA is not required, you need to understand where your personal data is being stored within your organization. So for companies already operating under the GDPR, much of this infrastructure will probably exist. So it'll feel familiar to you, but you will still need to understand, again, like we were saying, the cultural differences between the two jurisdictions. And like from my understanding, the GDPR, again, it's a more mature regime because it started in 2018. There was a strong lead up to it as well. People were preparing for it for 2 years. We only have 3 years of enforcement with the federal law. So the GDPR has, like, the rights under the GDPR, in my opinion, are broader, and they're more easily enforceable at the moment. But again, with the executive regulations, we'll probably see that changing as we move forward with the UAE Federal law. They're more explicit and they're more granular. Whereas the rights with the PDPL, they're more general and they're fleshed out. They will be probably fleshed out through executive regulations, like you said. And there's more kind of regulator discretion, I think, to interpret the rights under the UAE PDPL. So yeah, I think so. They're very similar, but again, the GDPR is that little bit further down the line, so it's the rights are more kind of mature, I think. But in the future, we'll probably see that being refined going forward under the UAE as well. So question 7 for you, Katie. International data transfers are a major concern for businesses. How are cross-border transfers regulated under the federal UAE framework?
Thanks, Maria. So, international data transfers under the UAE federal law are conceptually similar to the GDPR, as we see again and again. On the surface, you might just think it's the same, but you do have to look into it more. So they do have adequacy, like the GDPR, and where an adequacy decision is relevant, it's a lot more like the GDPR, because so they have two situations: an international transfer where there's an adequacy decision or an adequate level of protection, or where there isn't adequacy, they have specific conditions or exceptions that apply. And the specific conditions is where it diverges from GDPR more, in my opinion. They have a couple of considerations for what constitutes an adequate level of protection, which to me is quite similar to the GDPR. Like, a state that has adequate protection is going to have controls for privacy, a regulatory authority imposing the regulation, and they've also said they need to have the ability to exercise the data subject's rights. So it is quite similar to the GDPR there, like, especially with the data subject's rights. I mean, that's a lot of people's main concerns, with their citizens' personal data. Are they going to have the same rights if their data is transferred? So that's quite similar, in my opinion. The exemptions are a bit different. They include explicit consent of the individual, performance of a contract, public interest, vital interests.
So when you say exemptions, these are exemptions from adequacy decisions, is it, or?
It's so, yeah, it's where you can, where an international transfer will remain legal in the absence of an adequacy decision.
Okay. So alternative safeguards, kind of like under the GDPR.
Yeah.
Yeah.
So
that's consent, contract. What was the other one?
Consent, contract, vital interests, public interests.
Okay. But that's quite general, actually, isn't it? So,
it is quite general.
So that would kind of leave it more up to the regulators to interpret what that would be public interest,
Yeah, like there's a lot more detail about international transfers in the free zone laws.
Yeah.
That is a common thread with the PDPL. It does have the sections on international transfers, but it is very, high level now anyway.
So again, that leaves it to the regulator's discretion to interpret what is meant by the law. Yeah. Okay.
I'll move on to your next question, Maria, in relation to data breaches. So what are the breach notification obligations under the federal PDPL?
Okay, thanks, Katie. So under the federal data protection law, organizations have an obligation to notify the regulator of personal data breaches that may affect the privacy, the confidentiality, or the security of personal data. Where a breach poses a risk to individuals, affected data subjects must also be informed, and that's again similar to the GDPR. While the law does not mirror the GDPR's 72-hour rule verbatim, it places a strong emphasis on the fact that they should promptly notify people involved and expects organizations to act without undue delay once a breach is identified. So they don't they don't oblige an organization to report the breach within 72 hours like the GDPR, but they do actually say it needs to be prompt notification. So in practice, this means that businesses need to have a well-rehearsed incident response process like the GDPR. So if it's going to be prompt, you need to be able to enact your response, your breach response fairly quickly. So you don't rely on ad hoc reactions. So organizations should be able to quickly assess the nature and impact of a breach, determine whether notification thresholds are met, and coordinate internal teams to engage with regulators and any individuals that are involved. So again, companies that would be working under the GDPR would be familiar with this kind of approach. And the overall approach will feel similar, but the timelines, the thresholds, and the reporting expectations would be different. And again, I think from just trying to understand the differences, the breach notifications that you would have to carry out under the federal law as opposed to the GDPR it's much more kind of risk based. So you'd have to assess, okay, is this going to be a risk to the data subject? And so we'll have to notify the regulator or notify the data subject. Whereas with the GDPR, it's much more kind of like we have to notify first, kind of, if there is some sort of harm. So I think the threshold is lower for reporting in the GDPR than it is for the UAE federal law. But, they're very similar in the way that they approach data breaches. So moving on to question 9 then, Katie, for you. What governance and accountability requirements do organizations need to be aware of when operating under the federal law in the UAE?
Okay, so when it comes to federal laws, it does depend on, again, what sector you are operating in. So for an organization that's subject to the PDPL alone, you're going to have to maintain your record of processing activities, very similar information to the GDPR. You're going to need to continue doing your due diligence with your processors and sub-processors. You need to have your documentation centralized and ready to present to the Bureau. You're going to need to implement the appropriate technical and organizational measures to protect the data. There is a kind of another tier where your processing represents a higher risk to confidentiality and privacy of data subjects' personal data, or where there's systematic automated processing, or where you handle large volumes of sensitive personal data. So in those situations, you're going to have to appoint a data protection officer, a DPO, and they're going to have a role very similar to the GDPR. And In those situations, you're also going to have to carry out a data protection impact assessment to identify and mitigate the risks to individuals. So that's a lot of the same
Very similar. Yeah.
It is. But then you could go the step further. If you're in the financial sector, you definitely have more burdens, more regulatory burdens. So organizations that offer financial services need to have a comprehensive data management control framework. They have a series of additional controls required when it comes to digital transactions and digital data. They need to designate internal responsibility within their organization for data management, whether there's automated processing or not.
Okay.
So they all are going to need a DPO bit, essentially.
In the financial sector.
Yeah, or even a team. It doesn't matter if they don't have the sensitive data or if they don't have the automated processing. They need to have internal responsibilities no matter what. They also have more obligations when it comes to lawful bases. Like, one big difference of the PDPL, there's not that much information on lawful bases other than consent. Like, they have situations, they have basically consent as the gold standard, and then situations where you might not need consent. Whereas the sector-specific laws go into a bit more information about lawful bases, and you need to document them a bit more thoroughly. And they also, this is actually one similar point to the European regime, that they do have more additional retention periods to consider. Like, we have that in Ireland too when it comes to financial information. So that's one thing that's not different, actually. In the health sector, they also have additional obligations. Their main additional obligations are to do with transfers. So, like we said, the PDPL, it doesn't go into that much detail about transfers. But in the health sector, an organisation is limited from storing, processing, or transferring health information and data outside of the UAE, except by express decisions relevant to their relevant emirate or jurisdiction which they're based in. So just another layer of protection there to be aware.
That's not based on consent then. So there's a different consideration there. Is that correct?
Well, yeah, I suppose it's not based on consent if it's based on the Emirates decision, but that is one difference of, like, you see that in the sector-specific laws and the free zone laws, that the overarching federal PDPL doesn't give as much attention to lawful bases as every other law that might be applicable. Like, they go into a lot more detail when it comes to that, actually, which is a notable distinction. So, yeah, basically, no matter what, there is going to be you are going to need to define responsibilities and senior level oversight to data management processes. You always need to document your decision making. You always need to document what personal data you have and the purposes for processing. You need your policies, training, vendor management, and risk assessments at a federal level. And then once you are in those other sectors, you just need to go that little bit step further in certain areas. So it is quite like GDPR style accountability.
Just one question. Does the UAE specify, like in the GDPR, special category data, or is it just personal data like we had with the DPDP in India?
They have special category data, and they define it as any data which directly or indirectly reveals a natural person's family, ethnic origin, political or philosophical opinions, religious beliefs, criminal record, biometric data, or any data relating to such person's health and physical, psychological, mental, genetic, or sexual condition, including information related to the provision of healthcare services. So that's actually interesting that a lot of these Gulf regions have considered data related to your family or your lineage to be special category data. And another thing to note that they do include someone's sexual life or sexual condition, as they put it, and not all the Gulf regions include that in special category data. So that was actually a good question.
That's interesting, isn't it? Yeah. So it's similar in that respect to the GDPR then. Does it include financial data as special category data?
No, it's not special category. So then that's also, one distinction with the sector specific law, that they say, in the PDPL, you need your DPO if you handle a large amount of special category data. Financial data is not special category data, but still you have these further obligations.
Again, very similar then to, the GDPR in that respect.
Yeah. So I'll move on to question 10 here for you, Maria. How active is enforcement in practice under the federal law, and what penalties can organisations face?
Thanks, Katie. So enforcement under the UAE Federal Data Protection Law, it's still relatively early stage. So again, we've spoken about how it's only about 3 years of enforcement at the moment. It's still not as mature as the GDPR. So it's still early stage, and particularly when compared to the mature and highly visible enforcement landscapes, again, like the GDPR. The regulatory framework provides the competent authority with powers to investigate non-compliance, issue corrective measures, and to impose administrative penalties. So again, it's high level, I would say similar at a high level to the GDPR. But enforcement practice is still evolving as a regime beds down and organizations adjust to the law's requirements. So for businesses, this does not mean enforcement risk can be ignored. The law allows for financial penalties still. So if you're not compliant, you could still be subject to financial fines, corrective orders, and of course the reputational consequences can be quite huge, and that's another reason why they brought this law into effect anyway in the first place, to increase trust in the kind of the business landscape of the country. So all regulators are expected to become more active as guidances, executive regulations, implementing decisions, and supervisory capacity develop. In practice, organizations should treat this phase as a window to get governance and controls right, rather than like sitting back and thinking that, there's not much that they can do for the moment without the kind of executive regulations. Again, we have a lot of kind of support and guidance that you could look towards the GDPR or more mature kind of frameworks that have been in place for longer to get your compliance up and running. A demonstrable good faith compliance effort supported by documentation and operational controls is likely to be critical if and when the regulatory scrutiny increases. So again, work towards getting your ducks in order, so that when these executive regulations do come down the line, it's not going to be so onerous for your organization to comply. And I think that's very similar to what we're seeing now with the digital omnibus in Europe, in that, we have the enforcement of the EU AI Act coming down the line, and we have certain dates coming up, for high risk systems and so on the 2nd of August 2026. And now with the digital omnibus, there's a tendency, or there's a temptation to, think, there's nothing, they're pushing it out until 2027 or 2028. But again, it's important to know that they will eventually come. And so why are you waiting? Breaches don't wait for regulation to be brought into effect, so you're still at risk, even if the executive regulations under the UAE federal law haven't come out yet, it's important that you continue with your compliance regime because, data protection breaches and data protection subject access requests don't wait for the executive regulations either, so
Yeah,
don't waste time, I would say.
I definitely agree. Like, I think it's worthwhile to be conscientious about how you manage data, whether there is regulatory scrutiny or not, because at the end of the day, like, all of these data protection regulations are kind of rooted in the fundamental right to privacy. So I just feel like it's also just having a respect to kind of your employees and customers' personal data, whether or not you're going to get fined for it. It's
Absolutely.
good practice.
Totally agree. It's good practice. And as well, I think customers and employees, they get a sense for whether an organization is respectful of their personal data or not over time. Do you know what I mean?
Yeah.
So I think it's really important for organizations to build that trust because again, trust only comes with time, so
Exactly.
Demonstrate what you believe in. You know what I mean? That data protection is important to your organization. Yeah. Okay, so question 11 then, Katie. This is the penultimate question, so we're doing good for time. How well equipped is the federal UAE data protection framework to deal with artificial intelligence and emerging technologies?
So the PDPL, it does give attention to AI and emerging technologies. I mean, that is one of the biggest reasons why people are becoming so anxious about what is happening with personal data,
Yeah, true.
So they have their Article 18, which stipulates that data subjects have the right to object to any decisions that result from automated processing or decision making. This includes profiling. And it says, especially so, where those decisions are going to have a legal impact or an adverse impact on the data subject. So they do have some limitations on this right. This particular right is not absolute. They cannot object where the automated processing is subject to a contract that they have entered into with the controller, where it's provided under their legislation or regulation applicable to their emirate or jurisdiction. So, I just become a bit curious about that, like what laws might provide for automated decision making explicitly. And then in the third situation where they have given explicit consent, they do have an absolute right, which is to request that a human be in the loop when they are subject to automated processing. So there isn't any exemptions listed for that right, which, is quite a positive thing.
Good, yeah.
There is significant interpretive work on the part of organizations, and it is just one article, but it is there, and the fact that human in the loop doesn't have any exemptions, I consider to be quite a positive thing. So it can be bulked out more, like especially with the rate of how these technologies are adapting. And there is going to be more executive decisions, so there might be more details in the exact interpretation and implementation of this, maybe even more controls.
Does it have an equivalent of the EU AI Act? Do you know? I don't think it does.
I mean, the AI Act was the first one.
Yeah. I think it relies more on a mixture of national strategies, ethical principles, institutional frameworks, and kind of existing laws to kind of implement AI at the moment. And like you say, the data protection law is quite heavy on the protection of data when it comes to technology and so on.
In 2024, they officially established their Artificial Intelligence and Advanced Technology Council, and they're situated in Abu Dhabi.
Okay.
So They oversee advanced AI projects, research, infrastructure, and investment.
And I know that they have the UAE strategy for AI 2031, which is aiming to establish the UAE as a leader in AI. And they have goals around education, infrastructure, governance, and innovation in the country. So that's another piece that's important.
And the free zones have a bit more on AI, which I suppose we'll talk about in our next episode. But
Okay.
that's a PDPL, I suppose, in national, federal level anyway. So we'll move ahead here to our final question for you, Maria. So looking ahead, where do you see the federal UAE data protection regulation evolving, and what should organizations prioritize right now?
Thanks, Katie. So I think, looking ahead, the UAE's federal data protection regime is likely to evolve because, like I said, like we've said throughout the podcast, it only has 3 years of enforcement at the moment. So I think we're going to see greater regulatory guidances coming, clearer enforcement practices, closer alignment with international standards, rather than through wholesale legislative change. As the framework matures, we can expect more clarity on areas such as cross-border transfers, breach notification thresholds, and the application of data protection principles to advanced technologies like AI. So again, I think it's going to just mature as the years roll on and we get more and more enforcement. This will help move the law from a principle-based framework into a more operationally predictable regime like we're starting to see with the GDPR. Right now, organizations should prioritize waiting for the law, the PDPL, to mature. Organizations should prioritize getting the fundamentals right. And again, we have a lot of kind of guidance there when we look internationally at the GDPR and so on. That means understanding whether and how the federal laws apply to them. Because again, we said it's kind of a complex landscape. Mapping data flows, putting governance and accountability structures in place, and ensuring that they can respond to rights requests and incidents, data breaches and incidents in practice, not just on paper. So for businesses already compliant with the GDPR, the immediate task is not to reinvent the wheel, but to adapt governance to the federal PDPL, translating existing controls to fit the UAE's legal structure, its scope and regulatory expectations before enforcement activities become more established. Again, give it time and there'll be more and more kind of clarity with time. But again, like we said before, don't wait for that to happen. Just start with your governance now.
Yeah.
Okay, so that kind of brings us to the end of all our questions for this week. So this is the end of part 1, where we have explored the Federal United Arab Emirates Data Protection Law. In our next episode, we'll continue the series by turning to the Dubai Free Zones, and most specifically the DIFC and the ADGM, looking at how these regimes fit into the wider regional landscape. What's already clear is that while these frameworks are increasingly aligned with international standards, organizations operating in or targeting different jurisdictions need a structured, jurisdiction-specific approach to compliance. So thanks, Katie, for taking the time today to have this conversation. Thanks to our audience for listening. And don't forget to subscribe to the podcast. And please join us part 2 of this episode to help us unpack how privacy regulation is evolving in the free zones in the UAE.
Thank you.
Thanks, everyone. Thanks, Katie.